My name is Morgane Nicot. I work at UNODC, the United Nations Office on Drugs and Crime, and I'm a crime prevention and criminal justice officer at the Human Trafficking and Migrant Smuggling section. I have been working on migrant smuggling issues for the last 10 years and assisting states implement the protocol. This protocol against the smuggling of migrants is complementary to the Convention Against Transnational Organized Crime, so it considers migrant smuggling as a form of organized crime. And per se, it defines the smuggling of migrants with a criminal intent, which is to gain benefit, to make a profit out of the facilitation of the illegal entry or stay of third parties. What's important to understand is that member states to this protocol, and that includes all EU member states apart from one, are bound to criminalize migrant smuggling according to this definition. But those member states which are also within the EU have the Facilitation Directive, which is mandatory upon them to respect. And the Facilitation Directive was adopted before the European Union became party to the Smuggling of Migrants Protocol. So you have member states in the EU which have both the Facilitation Directive framework to respect, which is mandatory to them, as well as the international framework to respect. We have states in the EU which are both bound by the Facilitation Directive and by the international framework, the Migrant Smuggling Protocol, which don't say exactly the same thing. The international framework never intended to criminalize humanitarian work. It was really to go after organized crime groups, organized crime networks, and this type of criminal activity. While the Facilitation Directive is broader and in a sense does not restrict itself to this type of situation, but actually could be implemented in a way that would also bring to justice people who have been helping facilitating the illegal entry, helping migrants on the territory while not pursuing a financial gain. So out of humanity, out of solidarity, and so this is one of the issues we have been discussing and seeing as needing to be resolved. One of the options that the European Commission offers is to have a humanitarian clause that states could opt for, which would exempt from criminal prosecution those humanitarian workers and charity workers and other people who are acting in order to help migrants but without making a benefit or seeking a profit for themselves. The European Commission had an evaluation of its facilitation package in order to look at the impact it had and potentially on the impact it also had on humanitarian action. The problem, though, is that they did not manage to collect enough evidence that humanitarian action was prosecuted under the Facilitation Directive at the national level. And hence, they concluded that there was no need to review the Facilitation Directive and to potentially make the humanitarian clause mandatory, which we thought would be a good safeguard. There are efforts right now deployed to try and find more cases. Actually, UNODC also has a case law database looking into case law in implementation of legislation that relates to migrant smuggling or facilitation of illegal entry and analyzes it in order to see what impacts it can have. To put into question some fundamental principles here in the EU, but also in the whole world, that fall under the UN Charter, under the EU Charter of Fundamental Principles, or the European Convention on Human Rights, for example. It is very important to reconcile these principles with the obligations coming from securing the territory of a state, for example. There's a case that was decided upon in France by the Constitutional Court last year, which I think is very important. In that court case of the highest court in France, it was decided that the principle of fraternity needed to be considered and balanced with the need for security of the territory. And I think this is very important. Based on this reasoning, the French Constitutional Court overturned a judgment against a man who had been assisting migrants out of solidarity, out of humanity, housing these migrants next to the border with Italy. And the Constitutional Court found that the principle of fraternity should be balanced with the necessity to protect the security of the territory. And I think this is a very important step where the jurisdiction itself recognizes that these principles need to work together. You cannot ignore the fundamental principles, the human rights, when you're acting against organized crime or when you're acting against criminals in general. And this is a very, very important point that is valid both at the international level within the UN and at the EU level, and of course at the national level. EU member states do have their own protection of rights, and this should not be forgotten when we're addressing migrant smuggling or related crimes.